Good afternoon to one and all present here. On behalf of the Internal Quality Assurance Cell, I welcome you all for the certificate training program on IPR awareness. Today, amongst us, we have Amuda ma'am, who will be enlightening us on what IPR is and the importance of IPR. So, before moving on to the program, I kindly request Kanya ma'am, Dean Student Affairs, and also HOD IT and IQAC in charge to welcome the gathering. Ma'am.
Thank you, Aparna. Good afternoon, everyone. Respected dignitaries, esteemed faculty members, dear participants. It is a great pleasure to welcome you all to inauguration of certificate program on IPR awareness today organized by Internal Quality Assurance Cell of Dr. MGR Educational and Research Institute. First and foremost, we extend our heartfelt gratitude to our esteemed leader, Dr. A.C. Shanmugam sir, and President Engineer A.C. Saran Kumar sir for the continuous support and encouragement. I also thank our IQSC Director, Dr. Malini Pandey ma'am, and Deputy Director, Dr. Subhashi ma'am, and the team IQSC for the continuous support and encouragement. Today, we are having with us Professor Dr. Amuda ma'am. She's incubated in FIST TBI IIT Patna. Ma'am is going to deliver a talk on IPR awareness. We welcome you, ma'am. Happy to have you here. Thank you, ma'am. And also, I welcome all the participants, those who are joining us virtually through this virtual platform. Thank you for spending your valuable time with us, and hope you'll be an interactive participant. Kindly post your queries in the chat box. We'll be catching this. I am happy to welcome all the participants and coordinators of this event. Dr. Gomati, she's on out of station, and also I thank her for making this initiative. Once again, a warm welcome to each and every one of you. May this program be a rewarding and enriched experience for all of us. Stay tuned to Happy Learning. Thank you.
Thank you so much, ma'am, for that warm welcome. So, as we move towards the session, it's my privilege to introduce our chief guest for the day, Amuda ma'am. Dr. Amuda, she is currently an incubatee in FIST CBI at IIT Patna, Bihar, for prototyping her idea of Power Auto panel. She is also one of the designated partner and a registered Indian patent agent in MAAS Research Solution LLP in Madurai. She has completed her BE in Electrical and Electronic Engineering from the Government College of Engineering in Salem and ME in the year 2006 through GATE examination, which she has cleared in the year 2004. She did her PhD also in Power System from Indian Institute of Technology, Madras. Ma'am has undergone 1 year training in IPR program sponsored by the DST India under the Women Scientist Scheme C. She cleared the patent agent examination in 2018 and she was one of the 1,500 faculties who were selected under TQIP3 scheme of World Bank MHRD India. She has completed 3.9 years tenure successfully, holding various responsibilities and took various initiatives in Nalanda College of Engineering to impart quality of education. Ma'am has a teaching experience of around 4.8 years and 6 years of industrial experience. More than 20 articles in international journals, international conferences, and national conferences to her credit. She owned 2 patents and filed for 3 patents in India and 1 patent in US. Ma'am, we are extremely happy and privileged to have you here, ma'am. The session is to you. Over to you, ma'am.
Thank you, Abaruna, for your introduction. And first of all, I would like to thank Dr. MGR University management as well as the staff for giving me this opportunity to present before some basics of IPR. And I would request the participants, if you have any doubt in between, you can unmute yourself and you can ask me now and then. I think the facility is available with your streaming software, so you can unmute yourself, and whenever you have doubt you can ask me. Otherwise you can put it in the chat area also, but I can see the chat only at the end of the session. So if you have any doubt, please ask me in the beginning itself. And let me share my screen first. I think my screen is visible. So today we are going to see about the intellectual property rights, some of the basics, and there are like many sessions may be available after that also. If it is if you are preferring, then there will be other sessions will also be there. And actually, since I was introduced by Dr. Abarna, madam, so let me skip my introduction part. So let us go to the topic now. So what is the intellectual? So intellectual, it is a deep thinking of mankind. Okay, so our brain, it is a beautiful thing, and it was a complex thing also. So if you see, intellectual, it is a part of a human being, not only part of a human being, but also for living organisms also. But when you have critical thinking, then it obviously comes to a mankind, like human beings, right? So if you see our brain, there are different parts, and each is doing some different functions, right? For example, the frontal lobe. Frontal lobe is doing some problem solving, planning, creativity, reasoning, logic, as well as the temporal lobe. It is for memory, visual processing, recognition, musical awareness. Those who are interested in music, then their temporal lobe might be well developed one. And parietal lobe, it is a sensory processing, spatial perceptions, academic skills, and mathematics. For those people, the parietal lobe will be well developed. And occipital lobe, it is for visual perception, interruption, and color perceptions. Okay, so if you see these intellectuals, it is it is not available to one, not only for one human, one humans, but it is spread all over the world. Like humans are spread all over the world, and the intellectuals, different types of intellectuals also present all over the world. So actually we are going to see how these intellectuals are becoming property, and how it is being given rights by our legal systems, as well as how it can be protected, and what is the procedures, that also we can see in the lectures. Okay, so when it comes to the human beings, what in case of a bird, actually what is the intellectuals of the bird? Actually it can build the house according to the climate changes, and it can pursue have climatic conditions. Based on that, it can move from one place to another, and these kind of intellectuals they have. Okay, so similarly in case of a human being, actually we have different outcomes of the because of this intellectuals. And that only we are going to see. And but actually what the beauty of this intellectual property rights is, they are covering all the intellectuals of a human being. They are not leaving anyone. It is an inclusive approach of the intellectual property rights, because it is including all the human beings and their intellectuals. Okay, so they are giving rights to each and every individuals, I can say. Okay, so that is the beauty of this IPR. When compared to the other property, this property, it is not only, because in case of a tangible property, if you are seeing, some may be having some may be having more number of properties with them, tangible properties, but some may be without, like they may not have it. Okay, but when it comes to the intellectual property, every human being is having some intellectuals. So the right is being protected, and the right is being given to everyone, and the property also lies with everyone. So intellectual property rights, it is a just inclusive one, I can say, and it includes every human beings, I can say. Okay, so let us go through this type of IPRs. As I told you, this because of this intellectuals, there may be different forms of expressions or different forms of outcomes of this intellectuals, and these intellectuals are considered as a property nowadays because they are adding some economic value to it. Okay, and these economic values are help to improve those persons with that intellectuals, and they have, and not only helping them to improve their intellectuals, but also helping them to promote the word or sustain the word in terms of technology. Okay, in terms of technology, in terms of imaginations, in terms of literatures, like that, it can go. So in that case, this IPRs are divided into different types, and they have been classified into different types of IPRs in India. And there are 7 types of IPRs in India, and the eighth one, it is not available with India. It is not available in India, but it is available with US and other countries. So first, for example, if a creator is there and he gets some idea because of his intellectuals, and he is getting some idea with his interest as well as with his effort also. Okay, so with that one, like he is able to create these IPRs, and first one is patent, and second one is copyright, third one is trademark, fourth one is industrial design, fifth one is geographical indication, and sixth one is semiconductor IC design, and seventh one is plant varieties and farmers' rights, and the eighth one is trade secret, which is not available. So we are going to see all these 7 IPRs in today's sessions. And if you have any doubt in between, please let me know immediately. Okay. So now again, let me compare this brain with the IP. Okay, so like a pattern, it is like related to the new inventions. Okay, technical inventions. If it is a technical universities, then more patents will be coming out from them, not only from them but other universities also. But what I would like to say is more like a type of intellectual outcomes will be coming from those technical institutions. So their way of intellectuals is related to the innovative, analytic, and scientific nature of intellectuals they have, and they will be protected under the patent. Okay, and the second one, if it is artistic, expressive, or creative, some will be writing stories, music, and it comes out of their own creativity as well as from their own expression, way of expressing. So that comes under the copyright. And trademark, actually, trademark, it is I can say that it is a slight different thing when compared to the other IPs. Because this trademarks, it is other IPs, like other IPs, patent, copyright, geographical, other IPs actually related to that particular applicant or the individuals who is applying for the IP. But in case of the trademark, it is based on the response received from the customers. Okay, so that is a trademark, and trademark, it is a visual perception by the customers, not only by the applicant alone. Okay, so and it should be imaginative also, like once you saw the trademarks, you can imagine the product. Okay, so let us come to the slides later. And the geographical indication, based on the location, quality, reputations, you have the geographical indications. The geographical indications, we can compare it with the birds intellectual of having that knowledge on locations. Okay, similarly, the geographical indications, products, location based. Okay, so that also we are going to see. And fifth one is the industrial design. It is for the appearance sake, like it is like whatever the design they are making, it should be appealing to the ear, appealing to the eyes. Okay, so this industrial design and pattern, both are being confused in many institutes. I have seen that they are saying design pattern. In our country, there is no design pattern. We have only have the industrial design. Okay, please, when someone is saying that we are having a design pattern, please ask them whether you are having industrial design or patent, because in our country we have either patent or industrial design, not the design pattern. Design pattern is only available with the the US as well as other countries, okay, but not with the our country. Our country, it is industrial design. Industrial design means just appearance. There is no technical details included into it. So, but the pattern, they have the technical feature into it, okay. So that is the difference between the industrial design and pattern, okay. Patent will be having more value compared to the industrial design, because industrial design, it is for the outer appearance uh, based design, based certifications only. But in case of patent, it is related to technical details, okay. And other one is the semiconductor layout design. It is a new IP. It is like a recent IP. Other IPs are there for many centuries, but this semiconductor layout design IPs, it came later only. Okay, so it is based on like how the different transistors are being laid on the nanoscale level. Okay, transistors and other circuitries are being laid in that. So when you are placing transistors like within that small area, they should have some intellectuals of mapping, planning, as well as optimization, so that they can locate all these transistors and other circuit within that area, okay. So that intellectuals, they are giving the right of semiconductor layout design. It is in terms of like when your design is in terms of nanoscale, then you can go with the semiconductor layout design IP. Okay, and the last one is plant variety and farmers right. And plant variety, actually, obviously, like everyone is it is a part of our life, right? Without plants, we are nothing. So many are finding like many are investing in those plant varieties, and they have put their in like intellectual in developing it, in sustaining those plant varieties. So these IPs, these intellectuals can be protected using this plant variety. And farmers right, actually, since it is our India is agricultural land, the farmers right is being included into the plant variety. Only in India they have included the farmers right, okay. In other countries, if you are seeing, they will be having only the plant variety IP, not the other things. But in our country, actually, farmers right is being added to it, okay, because ours is agriculture country and traditional knowledge is being there. Therefore, in order to protect the rights of the farmers, they have included the farmers right, and this right is available only in India, okay. So, and again, if you are classifying these brain with the IPs, we can see that the right hand side, it is a fully of music, arts, creativity, imaginations. And in case of a left hand side, if you see, it is the analysis, logical thinking, precision, scientific maths and science skill. So the left side will be used most of the, just it is a simple comparison. Most of the IPs are being IPs IPs created from the left hand side, and that are patents, because that is like a technical things, right? So it requires analysis as well as logical thinking also. So the pattern obviously will come in the left hand side. And semiconductor layout design, as I told you, replacement of these transistors, it will take some intellectuals, right? No, like not everyone can accommodate a space with that transistors or circuitry, right? Some special skill is required for that. So it is this IP also comes from the left hand side of your brain. And plant variety as well as farmers right, it is also requiring some thinking of your ancient culturing technologies, and new technologies also, they have to combine all these things. So it also requires some analysis, logic thinking. So it also comes from the left hand side. Whereas if you see this copyright, trademark, as I told you, trademark, it will be coming a little bit different way of classifying in this left hand side, right hand side. And this copyright, industrial design, GI, all comes like a creativity, right? It comes with the creativity. So it is comes from the right hand part of the brain. So if you see brain, actually, as I told you, this all these IPs are inclusive of nature. It covers all the areas of the human intellectuals. So no human being is left alone, okay. So that is the beauty of this IPR. So with this, let me go to the IPR needs as well as other slides also. Before that, let me know if you are having any doubt on this. How many of you know these IPs? How many of you know these IPs? Heard it before? Actually, either you can unmute yourself and you can talk, otherwise, like you can put it in the chat also. Uh, Anyone? Have you anyone heard about these IPs, or it is a new one? Okay, since there is no, yeah. So let it be an interactive one actually, so that like because why I'm saying is like many are again and again making a mistake that patent and design, industrial design, they are considering it as one. Okay, I have heard many cases, particularly that's why I want to stress in this case. Like many are saying design pattern, there is no design pattern in India. Okay, and there is only we have the industrial design as well as patent is separate. Okay, so when someone is asking or telling you design patterns, mention them that this is not a pattern. Okay, so it is not giving a technical rights. Okay, that we are going to see anyway. Since the participants has not responded, so let me continue with my slides. I think we can go with the one-way communications. Need for IPR. Actually, what is the need? What is the need requirement for this IPRs? Why we have to go for this? Okay, and why it is gaining importance nowadays? Not only nowadays, actually, when you are seeing these intellectual property, when the human comes into the earth, actually the intellectual also comes into that but why it is getting importance nowadays? Because nowadays we are giving some economic importance to this intellectual property. Till now we are giving the importance to the tangible property, but now onwards we are going to give importance to the intangible property, and that is the intellectual. Okay, so that's why this we are going into this intellectual property rights, and the world is going to not going as well as going to be surrounded by this IPR economics only. Okay, so what is the need for this IPR? It should be the IPR should be protected from stealing, and if there is unauthorized occupations, it has to be protected from that also, as well as infringement. So for the protection, it needs the IPR rights, because when you are saying that it is right, it means that the legal obligation is given to you for that intellectual property. Okay, so that's why like it is an intellectual property rights it is given. So law is giving you protection, and why it is given protection? It is protection given for the IP of your IP from being stealed by someone else, or unauthorized occupation or acquisition, as well as infringement. As I told you, this is giving an economic right for the creators as well as innovators. They can market their IP, and they can get the monetary benefits also, as well as they can commercialize it and commercialize it also, and develop their intellectual properties. As well as they are giving the moral rights to the creators. And the third need for that is it is giving the right to the public in accessing, because the public they are also, they are the customers, right? They should get the right product, right? So sometimes they may be saying that this is a Darjeeling tea, but that may not be Darjeeling tea, right? So in that cases, like that they, to avoid the frauds from this like kind of things. So it is the government duty to give the right product to the public, right? So that is also, that's why this IPR comes into picture, because the public needs to access those IP related creators and innovations without any cheating. Okay, and and the fourth one is to create to promote creativity and innovations. Okay, so these IPs, if you are encouraging it, automatically it will be developing, and it is, as I told you already, that it is necessary for the sustainability of our earth itself. Okay, so the innovations or creativity, it is required. Okay, so whenever the creativity and the innovations required, our life will becomes a wonderful thing, right? Otherwise it becomes like a dull one, right? So this to sustain itself, we need the innovations and creativity. That's why we are going for this IPR. Okay, so these are the need. These are the points regarding the need for IPR. Okay, now let us see what is the procedure for getting the IPRs. Okay, so for example, now you get an idea. Okay, so you got an idea like different IPs. Whether you can write some stories also, or you can make some musics also, or you have innocence also, you can make some idea creations. Some creations will be given. Okay, so for after that idea creations, then execution, you have to do the executions. Okay, so in case of executions, not your idea will be in your mind, then that cannot be protected, right? That cannot, it should take some form, right? The ideas or the intellectuals, it should take some form, right? And that we are giving as a like a execution. Okay, so you have to execute that idea. Okay, and after executing, you have to search it. Okay, you have to search whether it is already available in the public or not. Okay, so you have to search it whether it is available in the public or not. Okay, and after that, you have to document it. You have to properly document it. Document your execution, not only your idea. Okay, so only your execution get it be like your executions only will be protected. Okay, so after execution, you have to properly document it, and then you have to go for filing. Okay, after filing, it will be getting automatically published. Okay, without any after record months, that is 18 months. After 18 months, it will be automatically published. Like it is different from the journal writing. Okay, in case of journal writing, first you will be going through the examination, after that you will be published, it will be published. But in case of IPR, first it will be published, after that only examination goes on. Because why it is going for the publication? Because it wants to tell the public that this invention has come up. If anyone is opposing it, if anyone is filing the oppositions, then they can file it. That's why it is being published. And once you are opposing it, then there is separate procedure which is not shown here. But if it is, there is no opposition, then it goes for the examinations. Whether if it is opposition is there or not, it will go for the examinations once you paid the fees. After examination, it will be granted or not granted according to the documentation part. They will decide it, and they will have some hearings also. After that, once you got the grant, then you have to renew it. Okay, so you have to have the renewal. You have to every year you have to renew till the period of the IPs. Each and every IPs have different types terms or the time period. Valid time period for the IP. Okay, so if till that period, you have to renew it each year after year. Okay, after that, you can like once you renew it or once you got the patent, then you can go for the commercialization or some technology transfers. So this is the general procedure for IPs. There may be slight changes, but the general thing is like this is the general procedure for all IPs. Okay, examinations, everything is there. And what are the Indian legal systems for IPs that protects this IPR? And you can see that each and every IP, it is protected by the some act. The Patents Act 1970. Okay, actually the Patent Act, it was in the 18th century, 1856, something like that. Okay, so but it has been restructured every now and then, and whatever today it reminds us that the Patent Act 1970. Okay, so and the Design Act 2000 is is the act which is protecting the industrial design. Again, I'm saying industrial design is different and patent is different. Industrial design, we don't have the design patents. Okay, design and patent is different. Trademark Act 1999 and Copyright Act 1954. 57, sorry, 1957. Layout design of semiconductor integrated circuit, that's Semiconductor Integrated Layout Design Act 2000. Okay, so as I told you, this is the act which came lately. It is in 2000 only. This layout semiconductor integrated circuit layout design came. And production of undisclosed information, this is related to the trademark. Okay, no exclusive legislation exists, but okay, contract acts 1872, because we don't have the trade secret, but it is covered under the contract act 1872. Okay, and the geographical indication of goods act, it also comes in 1999 only. And plant variety farmers rights act 2001. Okay, so these are the acts and which is protecting this IPRs, which is giving the rights as well as protecting those IPRs. And apart from these acts and rules, there are other acts also which we need to concentrate while filing this IPR. Filing this IPR. The first one is the Information Technology Act 2000. Okay, suppose if your invention is related to, if your invention is related to computer science, and if you want to file the patent for that, apart from the Patent Act 1970, you have to look for this Information Technology Act also. Okay, so both are like you have to go through this Information Technology Act. After that only you can go with the Patent Act. Okay, so if it is restricted in the Information Technology Act, then you cannot go with the Patent Act. Okay, then you can say that like unnecessary wastage of money can be avoided. So once you go through the Information Technology Act, if it is saying that it cannot be patented, then you can avoid using that going for patenting. Okay, and other laws are IPR enforcement rules, the Competition Act 2002, the Biological Diversity Act 2001. Okay, so if your invention is having biological material, for example, nowadays they are making some certs with the help of banana leaf fibers, right? Banana leaf fibers. So banana leaf fiber is a biological material. So before applying for the patent, you have to get the permission from the biotechnology department, as per the Biological Diversity Act. Once you got the permission, then only you can apply for the patent. Okay, you can apply for the patent, but they will be granting it only if you get the permission from the biotechnology department. Okay, otherwise they will not going to grant you. So these acts also you should know before applying for any IPs. Sorry. And where you have to apply. Okay, so the patent office is available all over India, and each and every IPs it has a jurisdiction area. So according to your jurisdictions, you have to apply for the patents. Okay, for example, if you are applying for a patent, then the patent office available is in Kolkata, Delhi, Chennai, Mumbai. Tamil Nadu comes under automatically this Chennai zone. So Tamil Nadu, Karnataka, Andhra, Kerala all comes under this Chennai zone. So whenever they want to file or communicate with the patent office, then they have to communicate with the Chennai office only. They have to send their applications to the Chennai office only. Okay, nowadays all the applications related to IPs are gone from when it can be done in two ways. Like a physical filing also you can do, online filing also you can do. But online filing actually it will, the jurisdiction will be automatically it is taking it. But if you are filling that state of your domicile, then automatically it is taking that particular office. Okay, so if you are typing Tamil Nadu, then Chennai office is being selected there. Okay, and in case of a design office, only Kolkata office is available. Okay, and in case of trademark registry, there is like a Mumbai, Delhi, Kolkata, Chennai, Ahmedabad is there. Geographical indication, Chennai is there. Chennai, it is the only office for getting the GI. It receives application from all over India. And semiconductor IC layout design registry, it is available only in Delhi, similar to copyright registry. Copyright registry also available only in Delhi. Apart from that, if you want to have some IPR related courses, then you can go to this Rajiv Gandhi National Institute of IP, Intellectual Property and Management. They are particularly, it is in Nagpur, and it is particularly giving trainings on IPR as well as IPR and other related things. Okay. Um, and if you see this IPR, it comes under the Office of Controller General of Patents, Designs, Trademarks, and again this comes under the Department for Promotion of Industry and Internal Trade, and again this will be under the Ministry of Commerce and Industry. Okay, so these are the hierarchy of governmental organizations which is maintaining these IPRs. And let me go through this patents. Okay, so let us go through this each and every patent document, like each and every IPs from this slide onwards. Okay, so patents, if you see this it as I told you, this is for the innovations, right? Like technical innovations, it comes for the technical innovations, technical inventions, I can say. And as I told you, like patents are not a new thing, it is coming from yearly like 1857 onwards. So like first Indian patent that was granted is for the deepening for the panka pulling machine. It is in Kolkata. Actually, he got the patent for panka pulling machine in Kolkata, and that was the first patent he got it. In India, it was granted, and again it was like a patent. It was governed by this Patent Act 1970, and this is the monopoly right or exclusive right or territorial right given to the applicant. Okay, so what is a monopoly right? Monopoly right, it only the applicant will be having all the rights. Okay, and will be having all the rights, exclusive rights he or she have. And territorial right, it is like once he got the patent in India, then he can do the business only in India. Like, not he can do business in other countries also, but the right will be protected only in India. Okay, so that is the territorial rights. Each and for every other countries also you have to apply and then you can get it. So it is a territorial right. It means that each and every country you have to apply and you have to get the right of the patent. Okay, and it is like as I told you, it is a technical related things. It is a techno legal rights it is given, and it is for the period of 20 years. It is a period of 20 years techno like rights is being given, and after that it is going to the public. Okay, after that anyone can do the business. Anyway, nowadays, like earlier 20 days was a big like a large number of years to do their businesses, but nowadays technologies are coming rapidly, that's why like 20 years it's even next year you can see the new technology, right? So this 20 years period, it is very long nowadays. Preventing others from making, using, selling, and offering. How it is preventing? Like what it is preventing? What it is preventing others from making, using, selling, offering for sales, or importing. Okay, so it protects the others from making of your product and using and selling. Rights are being protected for you. And patentability criteria, if you are saying based on the criteria only, you will be granted these based on the criteria only you will be given the patent or not. Okay, so what are the criteria? The four criteria are there. First one is like based on the laws, like under section 3 and 4. Actually, it is of the Patent Act 1970. It is telling whether that invention can be patentable or not. Okay, some invention that cannot be patented. For example, it is dangerous to the human beings, then it cannot be patented. And if it is a literary work, then it cannot be patented, but it can be done only in the copyright. So these kind of instructions are given in this under section 3. So before applying for a patent, you have to ensure that whether which IP you belong to, right? Which your which IP or right you are going to seek for your invention or for your creativity. Okay, so in that cases you have to go through this section 3 and 4 of the Patent Act 1970, and then you then only you have to decide which IP you have to go. Okay, so for example, if you are doing some medical treatment, then it doesn't comes under the patent, so you cannot get the patent for that. So before applying for the patent, you have to go through the section 3 and 4 of the Patent Act 1970. Okay, so this one, it is for the applicant. Okay, this is for the applicant. Before applying, we have to look into, anyway, doing examination also, these points are being looked into. But in the examinations, these 3 points will be, once if you are passing these one, okay, once we are passing these section 3 and 4 of the Patent Act 1970, then you have, then the examiner will go through these 3 criteria: novelty, inventive step, and industrial applicability. Novelty means it is not non anticipated. Inventive step, non obviousness, and industrial applicability, utility. Let us see with an example. Okay, novelty means it should be a new one. It should not be published or used or known or available or worked across the world in any forms. Okay, so it should be a new one. New, everyone should, like even the ordinary people should tell that it is a new one. Okay, so then it becomes a novelty. Novelty is governed by the section 2 of 1 of L. And for the novelty examples, actually we usually have these examples. Okay, so I'm showing the same. Actually, we have a single rod, iron rod, or stainless steel rods we are having. Okay, and with that rod itself, we have some different inventions being patented. Actually, these are being invention as well as novelty as well as inventive step. But for example of novelty, I'm just saying, okay, all these are needles, right? So needles, when you are comparing, all these are rods. Okay, when comes to the pattern, it means like they will check it as a rod. Rod means it is a stick kind of thing, right? So every rod or all are rods, so that is not new. Okay, but when you look into the features, then you can see that there are new features are available. So if you see the needle of this one, it has a hole at the back side, right? It has a hole at the back side. And and if you see this one, there is a hole at the front side. Okay, so what is the difference between those things? Like there is a hole in the rod, right? There is not new one. First, when you are having a needle and putting a small hole in it, it becomes novel, because within the small rod you are able to put the hole, right? So that becomes a new thing. But when you comes to this one, actually there is a hole here also, there is a hole here also. What is the difference of that one? So that is not new one. Okay, once you are able to put a hole in that, you will be able to put a hole in this also, right? So that is not a new thing. Okay, but still it becomes a novel, because like if you see the end of this one, it is a broader one when compared to this one, right? So there is a other one, and you can see that there is a small gap in that needle also. So that becomes a new one when compared to this one. Okay, and when you compare this again, this one, there is a hole here also, there is a hole. But what is the difference? The hole is going through the rod. Okay, into the rod it is going. So here and all, you can see that it is passing from the one end to other end, not from the one end to other end. It is passing through the one end only. Okay, if you go through this one, the hole is going through all over the body of that needle. Okay, so it means that that is a new thing, right? That is a new thing. Whereas in this case, there is this needles are all stiff. Okay, it is fixed one. Whereas this needle is a flexible one. Okay, so it becomes a new one. Okay, so identifying a new thing, when compared to the others, it becomes a novelty. Okay, that is the criteria we have to identify. Novelty means it should be new. Okay, you have to identify the feature which is new to when compared to the previous inventions. Okay, so each and every, this is easily being identified by every human beings. Okay, normal human beings also, they can identify. So novelty means it should be new one. Okay, and next one is the inventive step. Okay, so for the inventive step, actually it should be not obvious to the person skilled in the art. In novelty, it should be not available in the prior art. It will not be available in the prior art means all the public will be able to know if it is available in the available in the prior art, like everyone will know that. So for ordinary persons also, they can differentiate which is new and which is not new. Okay, in case of inventive step, it should not be obvious to the person skilled in the art. In this means only the expert can identify the difference. If he is able to identify the difference, then it becomes an inventive step. So with some examples we can see. And if you see here, different varieties of mobile phones or telephones we are seeing. We have seen only this one, but many are available from the earlier versions also. When you see that there is a inventive steps as well as the novelty, if you see here, if you see the speaker is one side as well as the mic is on the side, right? Speaker as well as mic on the other sides. Whereas in this case, the speaker and mic are in the same handle, okay, same handle. And also you can see that there is a dialing version of numbers is there. Okay, and when compared to here, the what is the new novelty here? The new novelty is like here you have to ring, you have to make a whole the numbers are like a different way, and here it is in the digital form, button system, buttons are there, so it is a new thing. And here if you see, there is a like a no wired kind of thing is there, only antennas are present, so the novelty is there. And here also the there is no antenna, it's like antenna is not coming out, actually it is a digital pieces. So you can see that this is a new thing. And in when compared to the other recent mobiles, you can see that there is no numbering system outside. So these are the novel things. On seeing this first, we can identify what is the new things in each and every individuals. But the person skilled in the art, actually they can identify what is the difference. Person skilled in the art, those who are in the communication systems, actually electronics and communication system, they can easily identify the difference between those things. In this one, they used to call the operator, telephone operator, and they will connect the call accordingly. Okay, so here actually what you can do is the trunking system is not available. You can directly dial the number and you will be getting to the, without going to the telephone operator, directly goes to the member person what whom you are calling. Okay, whereas in this case actually you are from this one, this is becomes analog one, and this becomes a digital technology comes into pictures. So the person skilled in the art, the expert can identify, but whereas the whatever we are telling physically, what like here I told you the speaker and speaker as well as the microphones are different, right? So, we here are different, and here it is on the same handle, right? So that are difference identified by any person. Okay, but the person skilled in the art should say that there is a certainly there is a difference, then it becomes an inventive step. So whenever you are applying for a patent, you also have to write in a such a way that the novelty inventive steps are achieved by your inventions. Okay, so you have to ensure that these things are achieved. Apart from that, you have the industrial applicability, so capable of being made and being used in the industry. For example, if you see these things, it is looking it doesn't have any utility. For example, if you see this cup, it is of different variety and you cannot drink it with that cup. Okay, so and if they see this umbrella, it is it can be looking nice, but it can be innovative also, new also. It cannot be inventive step, but anyway, if can be a novel also, but it cannot be industrial applicability. No one will buy it. Okay, one or two will buy it, but no one, many will not buy it. So industrial applicability is not there, so industry will not going to make it. And here also if you see the wheel of the car, if you see, it is a rectangle actually, then it becomes it is not of industrial applicability, it will not be purchased by the customers, so industry will not going to produce it, then it becomes a then it cannot, you cannot go with the patenting IP, but you can go with the other IPs. Okay, as I told you, no new things, whatever the intellect output of the intellectual, it cannot be left alone. Everything can be protected, but with different IPs. Okay, what I want to say is it cannot be protected under the patent. Okay, but it can be protected by the IP, other IPs. For example, it can be protected under design IPs. Okay, so that kind of no intellectual outcomes will not be left as such. Okay, everything will be included. Okay, so that is the criteria you have to check while writing your patent application or while doing your inventions. The for patenting, what you have to do is like three things you have to do, like novelty, inventive step, as well as the industrial applicability. Based on that, you can start writing your patents. Okay, so before that, writing patents, what can be patented and what cannot be patented, we have to look into it. So what can be patented? Product, system, apparatus, machines, or devices. The product means like physical products. You can make a patent. Otherwise, you can process the method or process or method. Like for example, if it is in a chemical reactions, you have like chemicals equations. In that case, the process, when, for example, when you are heating, when your temperature, how the temperature is maintaining, those are all comes under the process. Okay, and the method means like for example, some process, actually some products it is known, okay, but you are utilizing it in a different method of making it, then it becomes the like you can patent that also. Okay, so method of patent also protected in this. And chemical combinations, chemical compositions also you can do. For example, you are combining element A, B, and you are getting an element C, which is a novel and inventive step, as well as it has an industrial applicability, then certainly you can patent it. So these are the things you can be patented. And who can apply the natural, sorry, natural person, any person, a natural person or other natural person, suppose small entities, startups also can file it, provided they should be a true and first inventors. Like any person means they can be of inventors, those who have invented it. Invented natural persons means the you and me, right? Whereas in case of other than natural person means the small entity startups like that. Okay, so in that cases, like assignees of true and first inventors, they can file it. For example, if you are employed in a company or in a university, then university will be the applicant because it is providing you all the supports, like research, like a research lab it is providing, and additional technical staffs as well as student support. Or if the student is applying, then faculty support is being given by the university. So automatically the applicant should be the university. Okay, and in case of a company, the applicant should be the company. Okay, and company, or they are called as a assignee of the true and first inventor. However, you will be the inventor. Okay, you may be the inventor, but applicant will be the university or the other one, like university or the companies. Okay, and legal representative means like those who are the legal hires of the inventors, they can also apply it. Okay, whether they can apply it alone or jointly also, they can have some like for example, if some applicant is they are spending more in terms of efforts or money, then they can have the maximum 70% of their rights. Okay, rights can be like divided also. That also you can register with the IPO, Indian Patent Office. Okay, for example, 70% of the rights will be going to A, and 30% of right to going to B. That also you can explicitly write, and then can be that can be given to the IPO. Otherwise, if it is not given, it means that everyone will be having the equal rights. So, like A and B will be having both 50-50 right, 50-50% rights. Okay. So nowadays the university is also considering this. Like they are also considering the inventor along in the applicant name. Okay, so based on their some percentage, they will be including in the applicant name also. Based on their policies, they are doing it. And how and where to apply, and you can apply, as I told you, it can be applied online also, e-filing also you can do. Otherwise it can be done with the offline filing also, where you have extra charges for that. Okay, for a physical filing you may be having to pay the extra postal charges is that, so you have to pay for that. Okay, and you have to take the DD or something like that, and then you have to apply for that physically mode you can apply. But if you want to apply online, because online applications nowadays it is being easy one, and you can do, and it can be done with anywhere, from anywhere. Okay, so where you have to apply in India only you can apply. If you want to apply abroad, then you have to first get the permission from India. Suppose if your invention is there, they will be you have to get the permission from India to apply outside, because your invention should not be the secret maintained in India. Na? That's why you have to get the permission before applying outside. If your invention is done in India, then you have to get the permission from India. But if your invention is done in somewhere else, then you need not do, because you are going to apply from other areas only. Na? So you need not get permission. But if you are going to apply in other countries before applying in India, I'm saying. But if you are applying in India, after that, if you are moving, then it is easy process. There are two processes are there, PCT as well as conventional application is there, which I will in this one actually. Ordinary application is the one which we are going to apply, general thing, right? Like if you are going to apply from India, then the ordinary application will come into picture. But if you want to apply abroad, or if you are applying from other country to India, then you have to go with this PCT or conventional applications. Okay, so these are the different types of patent applications you have to understand. Ordinary application, it is from India alone. Okay, like from India, if you are applying, then it becomes ordinary application. But if you are going to apply to other countries or from other countries, then it becomes PCT or conventional application. Through that mode only you can say you can come. And I'm not going depth into it. And since it is the awareness program, just I want to tell you what are the different types of applications you can have. Okay, apart from that, you have some different applications like patent of addition and divisional applications are there. Patent of additions, for example, you have the inventions, but after 1 year you have some small improvements in your inventions. Now you want to file a patent for that. In that case, novelty or inventive step may fail in that case, right? Anyway, you should have a novelty and inventive step, and compared to the other, you should have. But when compared to your patent itself, your novelty and the inventive step may be lost. Okay, so in that case, then patent of addition will come into pictures. Okay, so it will be helpful. You are having the same invention, but you are having some small improvements over it. Then you have some technical advancement over the other applications. Then other applications means your previous applications. Then you can go with the patent of addition. Okay, whereas in case of a divisional application, suppose you have filed an application and the controller is finding that the invention is actually, we have to apply one application for one invention only. But in your application, if it is showing some two different inventions, then what the controller will do, he will be splitting up the applications. Okay, and that we will call it as a divisional application. Okay, so you have to divide the application, and then you have to file two patents. Okay, so that we are calling it as a divisional applications. In case of a national and international, national it is ordinary application, international it is PCT or conventional. Whereas these are the types of patent based on your inventions. Okay, so patent of addition and divisional applications. And for filing the forms, actually, application, it is costing around 1,600 for natural persons as well as the startups, MSMEs, like that. Actually, for universities also 1,600 only nowadays. But in case of a industry, big industry, then it becomes 8,000. And for Form 1, it is compulsory, which includes the contact details, the title of your inventions, and other declarations. You will be having it in Form 1. You have to declare the page numbers, other things in Form 1. And Form 2, it is a provisional or complete specifications. This is the one where you will be providing your information about your inventions. Okay, so there are two types of specifications. One is provisional and complete. Okay, so provisional, actually what you will do, it is a temporary applications. Okay, for example, like if you have found out some invention, but your invention is not complete, you will be completing within 1 year, then you can go with the provisional specifications. First you can provide the provisional specification, after that you can file the complete specifications. Okay, but your invention is complete at this instant itself, then you can file the complete specification directly. Okay, complete only tells that the invention is completed. Okay, for provisional, actually you will be getting 1 more year to come file your complete specifications. Okay, so specifications is very important, because based on that only they are going to decide the novelty, inventive steps, and industrial applicability. So and other conditions, criteria also they will be mentioning, they will be checking. So in that cases, like specifications should be drafted with very much which care also, and with precision also you have to do, because after that you cannot modify anything. You can delete some portions if it is not changing the subject matter of your invention. But if it is changing, they will not be allowing you to even delete it. Okay, so you have to draft the pattern specifications very carefully, because once you have drafted that, you cannot modify at any time. Okay, and other one is form 3 statement and undertaking, that if you are applying outside, then you have to share the details with the controllers. So those statement and declarations will be coming under form 3. And form 5, it is declaration as to inventorship. Suppose if there are so inventor and applicant is different, then you have to file the form 5. These are some of the important forms which you need to submit at the first instance. Mandatory, I can say. It is a mandatory form, you have to submit it. And the publication, as I told you, publication doesn't require any charges. But if you want to have after filing within 18 months, it will getting automatically published. Okay, but if you want to file it after like before 18 months, then you can go with the yearly publication. Yeah, ordinary publications there is no charges, but yearly publications it has charges around 2500 for the natural person or individuals, and 12500 for the industry persons. Okay, and form 18, it is for the request for examination. Publication there is no charges, but for examination you have to pay the charges. So it is around 4000. So for filing of patent, it may takes around 1600 plus 4000, so 5600 alone only to pay the fees, official fees, I can say, for filing the patent in India. Okay, so only 5600 it may take for official filing. But if why the cost of the patenting is very high, because of the other charges, professional charges we are making for this provisional and complete. Okay, if you are filing by yourself, it is around 5600 only. Okay, and if you are going to file with some other patent agent like us, then you have to file the form 26, mentioning that you are authorizing the patent agent, instead of you to file your application drafting as well as for filing also, and for prosecution also, you are authorizing the patent agent. That form 26 needs to be submitted. And if you are a startup or working startup or MSME, then you have to submit the form 27. uh, and form 4, it is for the extension of time. Okay, sorry, form 27, it is for statement regarding the working of patented inventions. Once you got the patent, then every 3 years nowadays, like every year, earlier it was every year, but nowadays it is 3 years. Every 3 years you have to inform the controller how it is working, whether you are working with the patent or not. That you have to inform through this form 27s. So these are the important forms you need to take care of while filing the patents. Okay, the patent, it is for 20 years, and from the date of filing. And the benefits, actually I have told you, it is like giving you the exclusive rights, territorial rights, monopoly right for you to build a business, or for commercialization of the rights also. The right, actually what you can do is, whether you are going to work it or not, otherwise you can sell it to the others also, otherwise you can give it a license also. Similar to our tangible property, here intangible property also can be done with the similar way of business you can do, like whether you can do the business by yourself, or you can sell it, or give the licensing also. Okay, so these are the patent certificate, Indian patent certificate, uh, sample patent certificate, but nowadays it is becoming different one. Actually here you can see the patent number, application numbers, date of filing it is given. Okay, and they have given the year of 20 years from that first day of February 2020, 2018. They have giving the term of patents also. Okay, So now we go through this copyright. Okay, so this copyright, it is governed by the Copyright Act 1957, and this right is given to the creators, for their creativity. The creativity takes different forms in our world. Okay, so it can be a literary work like books, pamphlets, poems, like that. Okay, even algorithms, when I'm saying, if you are writing a program and if you are trying to get the patent, they won't grant it. Okay, so they will not grant it because the programs and algorithms will come into the copyright. Okay, so it will be protected under the copyright. And some dramatic works, musical works, artistic works, and cinematography works all also come into the Copyright Act. Okay, so this rights is given to the expression, not for the ideas or procedures. Okay, no. Ideas and procedures, actually it will be different. It will be for it will be protected in different IPs. Okay, so procedure methods you can protect it by the patent IP. Okay, not by the copyright IP. Okay, so here if you are seeing in case of a patent, you have seen the three criteria: novelty, inventive step, as well as the industrial applicability. You have seen that as a criteria. Here the criteria is there should be original, need not be new one. For example, if you are reading a story, okay, so that story is you have read it and you want to express in a different way. Okay, then you can go with that. It becomes the copyright issue will not come. Okay, copyright issue will come only when you copy that and when you are publishing, then you will be having the copyright. But if you are expressing on your own terms, then the copyright issue will not come into picture. That's the one. Here it should not be new one. It need not be new one, but it should be a original one. Original means it should be done by the applicant. Okay, so it should be original one. It need not be copied one, but it need not be new one. Okay, suppose if someone is drawing a tree, you can also draw a tree, but if it is drawn by you, if it is different from that other one, then it becomes a copyright. You can file it, but you cannot copy and paste it. Okay, so the copyright issue will come into picture at that time. So similarly, if apart from national and international treaties also helps in getting this copyright in across all over the other countries, similar to what we have seen in the patents. It is a PCT as well as a conventional application. Here, the other treaties helps in getting the copyrights in other countries. Universal Copyright Convention and Bernese Convention, 1886. These are the two conventions actually. Based on that, you can get the copyright from the other countries. Okay. So in Rome conventions, actually there is some related or neighboring rights. For example, if a song is being taken, okay, so there are different players into it. Okay, the director will be there, and the composer will be there, musician will be there, actor will be there. So each and every one will be having their own right. Okay, so that we will call it as a related or neighboring rights. So right of performer, actor, singer, musicians, they are called as a right of performer. And producer of a program, sound recorders, and rights of broadcasters. So each and every one will be having rights, and they are called as a related rights, because for that particular song, they are all related, right? So it is a related or neighboring rights, you can say. And these copyright actually will also have some exceptions, in case of educational purpose. For example, in case of in taking a classes, okay, then copyright issues will not come into picture. Okay, they can teach you what your literature. Suppose if you are writing a sorry, books, and they are explaining in the class, then for the educational purpose, then it be like a copyright will not come into pictures. And legislation purpose also, suppose if you have written some books also, I am taking some reference from your books and showing it to the judge. Okay, so legislative members also, then that also, in that cases also, legislation purpose, the copyright issue will not come into pictures. And religious purpose, physically handicapped materials also, exceptions are there. Okay, and what is a fair use? You can use it, but with the conditions you have to use it. Okay, suppose if you are taking some text from some minimal text. Okay, whether you have to get the permission from, you have to get the permission from the particular author, and then you have to refer it along with the author's name, reference name, particular, like you have to cite their reference. Okay, cite their articles in your literatures. Okay, so that is considered as a fair use. Actually, this will be used in the research review, reporting current events, judicial proceedings also, considered as a fair use. Okay, here copyright, actually registration is not required. Once you have created, that is yours, it is considered as yours. Okay, but why we are asking you to register? Because it will be like a illegal product. For giving a legal production, it is required, need to be registered. Okay, even if you have registered, suppose if someone has copied yours and they have registered the copyright, then also you can file a case against him, because you can provide the dates when it was created, or the citations or the evidence. You can say that you have created it. So in that case also the copyright exists, because copyright mentions that it should be original. So even if you are not filing for patent, filing for copyright, but someone has filed it instead of you, then you can ask them to revoke it. Okay, so that is also possible. Suppose if you don't want to have the copyright IP being protected, then also you can take a case again. You can file a case against those person who is copying your um, idea in creativity. Okay, so when you are considering term of the copyright, actually this term is lifetime of the author plus 60 years, or if the author is not available, then it just becomes a 60 years. Okay, so like when compared to the patents, actually the copyright is having 60 years lifetime, because like these terms are being fixed based on the economical incomes. Okay, like incomes they are getting from these IPs. Okay, so for example, the copyright literature initially, like nowadays they are getting millions and trillion, like millions of monetary benefit. But earlier stages, selling a book, it is like a big issue, right? Selling there is a, because once a new for example, if music comes, if new music comes, automatically the first one becomes unpopular, like it becomes less popular among the public, and they may not be getting interested in buying it. Okay, so the lifetime it becomes very reducing. That's why they have increased the 60 years they have given in the copyright. Okay, creativity, it is getting rapidly changing now. That's why 60 years is being given. Whereas in case of patent, it is 20 years, because technical, it was believed that technical the spending on the technical invention is high, so they are taking, it may take some years to establish the industry to get the benefit from the IP. That's why they have given for 20 years. Okay, whereas in copyright it is for 60 years. How can you identify if it is a copyrighted or not? Then you can identify, then it can be identified by the symbol see like a C inscribed inside the circle. Okay, so inscribed inside the circle, you can see. So that means that it is a copyrighted. They have registered for the copyright. Okay, so you can see that it is copyrighted article. Okay, for registering this copyright, actually you have to file the form of 14 actually. And for changes in the particulars of suppose if you are changing some address changes, then you have to go with the form 15. Okay, however, in case of once you have given the your creations to the copyright office, then it cannot be changed. But other details you can change it. Okay, so and if you see the price fees for filing these copyrights, for different works, different ranges are being given. For literary works, it is literary, dramatic, musical, artistic work, it is 500. And similarly, sound recording, if you are getting IP, it is around 2000. If some changes are there, then you can, with the 1000 rupees, you can make some changes. Okay, and the copyright examples are it has been already seen, like novels, poems, plays, newspapers, computer programs, Computer programs, again I'm saying, it is coming under copyright. In case of a patent, it will not be protected in the patent. But what you can do is, like, you can put it in a like a flow chart, and then you can represent it. But however, you have to show there is a technical innovations into it, technical advancement into it, then only you will be getting the patent. Otherwise, it will be like, you will not get the patent, but you can protect it under the copyright. Okay, so these are some examples. Tom and Jerry, if you see, it is like a copyright of the animated pictures. Okay, so there is a copyright infringement cases nowadays are popularly going, like Ilayaraja versus SPB. Everyone knows that. And another one is the monkey selfie in 2011. Actually, here, what this uh, actually, there is a monkey. Actually, this monkey was like in the forest, and this David Slater, Indonesia forest. Actually, he was making some arrangement with the photos of like cameras, and he went for the break. Okay, the monkey came and took the picture of himself, and actually it was getting published. Okay, it was getting the monkey smile. It was very nice. So it was published, and it was gaining more popular. And he was gaining like benefits also. He was getting some benefits also. But later, the beta organization, what it told was the right should be given to the monkey nowadays. Okay, so instead of David Slater, it has to be given to the monkey. But what the judgment was given is, even though monkey has taken pictures, the David Slater, he was making the arrangements of the camera. So the intellectual comes from that arrangements. Okay, not from by clicking on the picture alone. Okay, giving an expression alone. The exact picture or comes from the settings of the camera. So yeah, the judgment was came in favor of David Slater, and he got the IP. And these are the patents, like sorry, copyright certificate issued by the Copyright Office Registry. And now let us go with the trademark. And third one is the trademark. And trademark, actually, it is a mark or the logo or something which is like on seeing itself, we can identify the quality of the product. Okay, so on quality of the product will be identified from that itself. For example, if you are seeing this Bata as well as the other slippers, on seeing itself, you can see the quality made by those Bata as well as the Amul. Okay, so Aquafina also, you can see that on seeing itself, you will be getting satisfied that, like, okay, I am getting the qualified product. Okay, apart like so that type of pictures, like that kind of visual perceptions, it is giving in our mind. Okay, so as I told you, the other IPs, actually it is coming out from the applicant's intellectual. Okay, whereas this IP, I can say that it comes under the customer's perception, not from the others. Okay, even if you have not applied for the trademark on immediately on starting of your company, you can apply the trademark after quite some time also. Okay, then also you will be getting a trademark, because like you are giving a you have introduced to your customer your product, right? That's why your customers becomes the will be helping you to get the trademarks, like okay. So this IP is slightly different from the other IPs. So it is a trademarks it is governed under the Trademarks Act 1999. It is a recognizable mark that helps and protects the consumers to identify, differentiate the goods, products, services from one another based on their quality and reputation, as I have told you. And Trademark Act, actually it is in India, but in other countries it is like other conventions and treaties are there. And particularly this Madrid Agreement as well as Madrid Protocol helps in getting the trademark in other countries, which I'm not going to depth into it. While coming to the trademark, applying for the trademark, actually you have to classify your product in terms of goods and services. Actually, it is called a nice classifications. In the nice classifications, goods are classified, like all the goods has been classified into the 1 to 34 classifications are there, and services also 35 to 45 it is there. And these classifications, if you see, it is related to the classification done by the Ministry of Commerce for any industries. For example, if it is a electrical products, like I'm not sure exact number, but for example, I'm saying if it is electrical goods, it may be protected under goods classification of 12. Okay, so the same classification will be available. If you check, it is more or less similar to other commercial things also, like classifications also, like there also it will be 12. Okay, so they have classified those goods only, not the marks. Okay, so they have classified the goods or services, and then they are giving the trademarks. Okay, so that same trademark can be used in the other services also, but you have to register it. Okay, sorry. Trademark, it can be a words, letters, or numerals. Okay, so it can be a slogans also, or it can be a characters. And I think I need not say much about this, because everyone knows, like different trademarks and logos are given in the advertisements, and you can see around us the boards, everything. Okay, so let me skip off these things. And if you see these, how you can identify whether the trademark is registered or the trademark is given, being applied, then you can check with this marks. Okay, so for example, if it is R is inside the circle, then it means that they have given the application for the trademark. Okay, they have given the application for the trademark. If it is written TM, it means that it has been approved by the trademark registry and it was done. Okay, so it was a registered trademark. Okay, so how it is, what is the criteria for this trademark selection? It should be distinctive and not descriptive. Okay, so only few words can be allowed in the trademarks, but not like a paragraph. You cannot get the trademark. For paragraphs, it is only copyright. Okay, and style is names and easy to pronounce, spell, no qualitative descriptions, good quality, that cannot be considered as a trademark. Okay, so not similar or identical, so it should not look similar or identical. I'm having some slides which you can also like identify how there is a similar between different trademarks. And the terms of trademarks is 10 years, for 10 years, and it can be renewal for every 10 years. Unlike patents or copyrights or other things, except this trademark and geographical indications, actually they don't have the end of lifetime period. Okay, end of lifetime period, because it is assumed under the concept of business, no, like going concern concept of business. Okay, so business will be going on without ending. So with that assumption only, business is being started. Similarly, the trademark was also given in that assumptions. Okay, so business will be going on without ending. So that, with that assumption, it is given. That's why every 10 years you have to renew it. Unless you are not renewing it, it will go on. Okay, so you can continue even after 100 years also. Okay, it is like for the industries, na? So like for the institutions, na? So it may be going from generation to generation. So the products and quality products and services will be obtained from it. Shows that the quality of that is maintained between this 100 to 200 years, right? So, and what is the main criteria is, like it should be original and new one. Okay, so it should be new one. Unlike copyright, it need not be new one, but it should be a original one. But in case of a trademark, it should be both original as well as new one. Okay, so some of the examples you can see, this Google, Unilever, as well as Amazon. Okay, so these are some of the examples of copyright. And the trademark applications, if you are seeing, the application for registration is 5,000, and if you are opposing this, then 10,000 has to be paid for opposition. And for renewal, it is again 10,000 for every year. You have to renew it. Okay, and why it is 10 in case of 5,000, after that it becomes 10,000. It is assumed that after 10 years its business is developed. Okay, that's why it is 10,000 it is being given. Okay, so if you are identifying the logo of Adidas as well as symbol, actually, you can see that there are variety of infringing logos or trademarks are available. So Adidas actually it is having some three lines, black lines are there, but you can see that there is four lines are there. So this is like a similar thing. Okay, so this is having some infringement, and similarly with the Nike as well as Nika, so there is some infringement cases are there. We can see that there is a tick mark here, here also tick mark there. So it can be original one of Nike as well as original of Nika means they are doing by themselves. Okay, if you see there is a distance, this like a distance between these two, and this two is very large. And also you can here you can mention like just do it in the logo itself they have written just do it, but here it must I make do it like that. Some variation is there. It can be original but not new. Okay, so you can see that it is not a new one. So cases are being filed, and they are right one is getting a like a eligible one is getting a their trademark rights also. And some infringement cases are there, and which I'm skipping it now. Okay, and trademark certificate is given to the trademark certificate. It is applied by the industry, and so the industrial name will be trade name will be coming here instead of the applicant name. In patent application, the applicant can be a natural person. Okay, but in trademark, it is actually companies. Okay, company names or trade names will be coming there. Okay, trade secrets, actually trade secret it is not in our India, but in US it is there. So for example, some information we will not even in the patent also, we are expected to disclose all the necessary information to prove our novelty, inventive step as well as industrial applicability. Some informations which is necessary, which is necessary to make that in patent invention, then you have to explicitly say. But if it is not necessary, then you can keep it as such yourself. But it is of your risk. Okay, it is at the hands of yours whether it can make it public or not public, and also the risk is yours. Okay, but once it is disclosed in the patent application, then once it is getting protected by the patent office, approval from the patent office to protect it, then you will be getting all the rights. But if it is not disclosed, then it is the you have to do all the protecting these informations. Some say trade secrets or formula, patents, compilations, programs. Okay, and even the employee records, some industries they want so many records and all, right? So it will not be available to the public, but of course it has to be available to the concerned authorities, but it may not be available to the public. Okay, so these are the some of the undisclosed informations that is considered as a trade secrets. In India, there is no trade secret IP is available, but in other countries it is available. KFC's 11 herbs and spices, Coca-Cola recipes, and Google search algorithm are some of the trade secrets. It is available. So if for example in the Coca-Cola recipe, since we don't have the IP, if it is exposed, then it is a loss to the company only. Okay, so because it is not being protected in India, but they may be going for the checking for the food qualities and other things, but the recipes are not known publicly. Okay, so it is up to their own risk whether how to protect it. Okay, so another one is industrial design. As I told you, this design, it is you should not be confused with the patent IP, because industrial design it is only for the feature of the same, no invention, no technical advancements should not be available with the industrial design. It is only the physical difference or physical patterns or something like that. Okay, so this design, industrial design, is protected under the Designs Act 2000. It should be original. There should be original and novel. New. It should be new as well as original should be there, and it is given to the shapes, pattern, configurations, combinations of line, colors, everything. Okay, 2D also, 3D also designs are available, and both of them are given protected under this Design Act. Okay, exceptions, mere change in size. For example, if you are making a small toy or a small dollar signs or something like that, like a pendant. Then same pendant, if you are making it as a larger one, then the design act will not say that both are different designs. Okay, both are same designs only, but say varying in size. Okay, so they will not consider as a different design. Okay, so that is the exceptional. And here are some of the examples, industrial design examples are being given. Okay, some chairs of this design and some pendant of this design is there. So it is only for appearance of ear. When you consider this dresses, I want to say the difference between the pattern and industrial design using this dress example. If you see that these dresses, if you are seeing, there are different sizes and different designs are there. Okay, you can go with the industrial design if there is no technical advancement. But if you see that there is some technical advancement into it, because like this best, it is flexible to our flexible, right? It is very flexible, and so that it can move inside our teeth and it can clean it, okay, efficiently. And this is simple one, so it need not be any technical advancement. But if you see this technical, if you see this breast, you can see that it is having some kind of a curvature, something like that. If it is of no technical advancement, then it cannot be covered under patent act. Okay, but if you consider this last one, it is for the small children's. Okay, they will not be able to hold these type of dresses because their hand structure is such that even with their small hand, they will not be able to, their holding mechanism is not well developed in those children's. Okay, so the technical advancement is given by making the broader size of the handle. Okay, so that the child can hold that breast. So there is a technical advancement mentioning that the child can hold it so that it will not fall from the hands of the hold from the hands of the children. So that becomes a technical advancement. So once there is a technical advancement, then you have to go with the patent IP instead of industrial IP, because patent IP has highly valued compared to industrial design IP. Okay, so industrial design, it may have some less monetary benefits or other benefits also, but patent benefit, it is very high. So I please ensure that you are going for patent or industrial design. In India, there is no design patent. Only in India, US, it is design patent is there. And again, I'm saying, because many I have seen in particularly technical universities, what they are doing is, instead of getting the patent, they are getting the design patent. They are mentioning like design patent is given. Okay, design patent, it is of less value. Your invention is getting lost into it. After that, if you are trying to file the patent application, it will not getting accepted in the patent applications, because your novelty will be lost, because you are publishing it outside. Okay, so your novelty will be lost. So ensure that whether you are going to file a patent or industrial design, have a clear idea of that, and then you start applying. Okay, so don't lose your inventions because of this confusions. Okay, and this industrial design, it is for 10, 15 years, 10 years plus 5 years, you can renew it. Okay, so but patent, you have to renew it every year. Okay, so it is a highly valued one. That's why you have to renew it every year. And the application for registration of the design is 1,000, and applicant for seeing every applicant, it is 500. For different applicants, you have to pay extra charges. And renewal of design, it was 2,000, and after 10 years you have to apply for the renewal. So in that cases, you have to pay extra 2,000. Okay, some case studies are there in case of infringement, case of industrial design. If you see Marico versus Raj Oil Mills, you can see that the parachute as well as Coca-Raj, both are having the same appearance. Okay, so you can see that bottle size, not only size, actually design wise also somewhat similar. Okay, so here it can be original, it should be original, and as well as new one. Okay, so it can be original one of parachute, or it can be original one of Coca-Raj, but when you compare to these two, it is not a new one. Okay, so there was a infringement cases against this Coca-Raj and like a patent. And parachute. And again, there is a famous infringement case of Apple versus Samsung. Actually, there is a like a Apple for iPhone as well as Samsung. You can see that there is a rounded bottom here, also rounded bottom. So something is different. Like a rounded bottom is there, but you can see that there is a like exact round is there, but there is some slight changes are there. So it is like they are saying that it is not being infringed. Okay, so back they have climbed for this particular curvature of the phone. Okay, so the infringement cases of design pattern doesn't stand actually before this Samsung, because they are having some different one. Okay, so design wise, actually, there is a less less valid, because many designs are coming into picture. Whereas the pattern, it takes a lot of years to work into it and get the outcome. And this is the registration certificate of the designs. Actually, it is given in the name of the applicant, and it is. Actually, you can see that numbers are being given. Okay, design number is being given, date, everything is being given there. Okay, and the geographical indication. Okay, so geographical indication, actually, each and every places will have some peculiar values or peculiar speciality with those locations. So those specialities are given the GI tag. Okay, we used to have call it as a GI tag, Geographical Indication of Goods Act 1999. Actually, it was governed by this act. And here, actually, when compared to the others, it is being given, trademark is given for the company, whereas the other rights are being given to the individuals. But whereas in case of a geographical indications, rights are not being given to the individuals. It is given it is given to the collection of individuals or to the associations. Why it was saying that, like in geographical indication, it is was given to the specialization of that particular location, right? So in the particular locations, many will be doing. It may be because of the water quality also. For example, if you're taking Manapara Murukku, it is having a different taste when compared to the other things. It may be because of the making, or it can be because of the water content also, or some like a skill, making skill also. Okay, so those things, it comes with the locality. Okay, because their minds are being, or the intellectuals are being practiced they are practicing and adopting that locations, and they are giving some specialized valued products, right? So products, so that's why these indications are being not given to a single individuals, but to an association of individuals only. Those who are making the products, those only they will be getting, the other persons will not get it. Okay, suppose if you are for example, if you are in the Manapare and you are going to do the Murku, then your locality should be there. Okay, otherwise you should be like doing the business for generation of the generation from the Manapare only. Then only you will be getting the geographical indications. Otherwise, you will not get it. Okay, you cannot do it in Chennai, and then you cannot claim for the geographical indications. You have to be there in that particular location only, and then only you can make your industry should be set up in that. Okay, then only you will be getting the geographical indications, and only those persons who are involved in that geographical indication, that is making of those product, then they only will be getting, not the others. Okay, and the terms will be for 10 years. Every 10 years it will be getting renewed. As I told you, this is similar to trademarks, because it is an industry, so it is a going concern concept. Because of that concept, actually, it is believed that the business will never end. Okay, similarly, the IP also for that particular trademark as well as the geographical indication will never end. Okay, so these are the some of the points on geographical indications. And you can see that there are different types of geographical indications being given to different products. Some of these are classified accordingly, like agricultural goods and service. Again, it was not service. Actually, service will not be included in the geographical indication. It is only related to the product only. Okay, so the agricultural goods, it is for basmati rice is being given, and handicraft goods, Mysore silk, and for Kanjipuram silk also we got it. And manufactured goods, Mysore agarbatti, those who are manufacturing it, they are getting it. And foodstuffs goods like Tirunelveli alva also, like this is agriculture means purely from the field they are getting it. Okay, so they are getting this GI tag. Okay, whereas the manufactured actually they are making some chemicals and using. Whereas in the case of foodstuff, they are making some additional process to the agriculture. Okay, so that's why like some classifications are being given, and the GI tag goods are being classified as 34 classes. You can see that trade secrets also, it is goods are classified as 1 to 34, and similarly this in geographical indications also 34 classes, because goods are being classified as 34 classes. Okay, like in India it is being classified as 34 classes only, that's why like geographical indication it is also 35. And for registration of GA you have to pay 5,000, and only authorized user can will be given the right to do the business, and in their sacket or like a product also they can make that GI tag. Okay, others cannot make a GI tag in that. Okay, okay, and also like a Tirunelveli alva means only Tirunelveli alva, those who are making, those who got the GI, they can only mention Tirunelveli alva, others cannot mention that name. Okay, so others cannot the makers of other alva from other places, they cannot mention like Tirunelveli alva. Okay, only those who are having the GI tag, they have to mention their name, otherwise they cannot, they will not be able to. Some of the examples of Sahi Lichi and Tanjavur painting, Mysore sandal soap, Manapari Murukku, Kanjipuram silks are some of the examples. And actually GI tag actually there is like some infringement cases are there. Tea Board India as versus ITC Limited, there is an infringement cases there. Tea Board actually they are having a Darjeeling tea. Okay, and ITC what they have launched is Darjeeling Launch. Okay, they have given the name of their product as Darjeeling Launch. Actually, they are for a hotel they have given the name, and there was a like a Tea Board was making some infringement case against this Darjeeling like ITC for making this Darjeeling Launch, and but what the judgment was given is Darjeeling tea, it is for a tea product. Okay, it is comes under the one classification. Whereas Darjeeling launch, it is coming under the different classification. So there is no infringement. So the judgment was given like no infringement with the Darjeeling tea versus Darjeeling launch, because the classification wise it is very different. That's why like once you are going with this GI, you have to be careful with the classifications also. Okay, so other cases, let me skip these cases, but you can refer in the websites also, and you can see that this is an example of a GI certificate. In the GI certificate actually you can see that only the name of the association will be given. Okay, so name of the industry will be given, not the other one, like not the individual names will not be given. Okay, so any number of association, for here actually two associations are there or two industries are there, their names are given, no single individual names are given there, like. Okay, and semiconductor layout design, actually as I told you, this semiconductor layout design, it is a recent layout design in 2000 only it came. And this one I have already explained you, like this is a layout of the transistor and other circuitry elements. You are going to make the in nanoscale, you are making the transistor and other circuit elements being placed on that nanoscale level, and you are going to accommodate all these things. So there requires a special skill for doing that. Okay, so that comes under the semiconductor layout design, because this is a new one. This came recently only, and the term for this is 10 years. And the criteria for this should be original and distinctive. Distinctive means it should be different from the others. Okay, it should be original and distinctive and capable of distinguishing from any other layout, and has not commercially exploited, means novelty should not be lost. Okay, so in our country, since our we are in the process of making the semiconductors in our country, till now we have only two semiconductor layout designs only. One is got by this ISRO and another one is by IPL. Actually, ISRO they have given the form of PCB. Usually, PCB form of will not be given. Maybe it will not come under the semiconductor layout design, but it will be coming under the copyright IP. Okay, but in case of a bell, actually you can see that there is a layout of different ICs as well as different numberings of the pins of those things. So these two only got the semiconductor IC layout. They have designed it and they have sent it outside and got back this one. Okay, but in our India, we are just going into the semiconductor industry. So we can expect in the near future, we can expect so other like any number of applications in the coming years. Okay, semiconductor IC layout design, it is for 10 years plus 5 years extension is there. Again, this is similar to the industrial design, but industrial design is for appealing. Okay, so it is not for the analyzing part of things, but here analysis everything comes into picture. So application for registration is 5,000, and other things I think we will skip those. And the last one is the plant variety. Actually, last one is the plant variety and farmers' right. This was come under this act, like a protection of the protection of plant variety and farmers' right act 2001. Okay, and farmers' variety means they might have done it from their traditionally, and that will be protected under this farmers' right. And other things are essentially derived varieties, genetically modified varieties, tissue culture. Other things are coming in this, the plant varieties. Okay, so what are the criteria they will be checking is novelty and distinctive. Novel, it should be new one and it should be different from the others. And the third, second one is like uniformity. So suppose if you are growing that particular variety in that field, every plant should be looking uniform height, uniform appearance, it should be there. Okay, and stability, every year it should have the same size and same height, everything uniformity should be maintained year after year. So we will call it as a dust test. So dust test, based on the dust test only, they will be providing the plant variety rights. Okay, apart from novelty, there is like a dust test you need to perform in different laboratories. For dust testing, it is like around 20,000. It should be 10,000. By mistake, it was there. Okay. And in terms of terms, actually, trees and vines, it is for 18 years, and for other crops, it is for 15 years. Okay. So because trees, it may takes a lot of years to conform with the test as well as other things. And it may takes a lot of years to grow it. That's why 18 years being given to it. And the international convention for this production is given by this UPVOV, International Convention for Production of New Varieties of Plants. Again, I'm saying like these plant variety is available in other countries also, but only the farmers' right is being included in India only. Okay, so these are some of the forms and fees. And there is a plant, some case studies are there. PepsiCo versus potato farmers and Monsanto BT cotton case is there. Actually, these are most important cases. And actually, these cases you can refer outside also. But one thing I would like to say is the Monsanto beta cotton. Actually, they have filed the beta cotton variety in patent. Okay, but after that, after the examination of the judgments, they have told that these beta cotton, it should be filed under the plant variety. Instead of patent, they have to file under the plant variety. Okay, so actually there was some case against this Nojivida as well as this Bayes, but I'm not going depth into it. But I want to say the difference between the which IP you need to submit. You need to submit it. Is like you have to analyze and then you have to submit it. Okay, so Monsanto, actually it is a BT cotton variety. Actually they have submitted in the patent. Okay, but patent IP, it says that plant variety cannot be protected under section 3 of Patent Act 1970. It says that plant variety cannot be protected. So Monsanto has to file again in the plant variety. Okay, so be careful in which IP your intellectual property has to be protected. You should be careful. Okay, so these are the certificates of plant variety. And apart from all these things, there is like one thing, traditional knowledge digital library. Our country is having large number of traditions from earlyhood, and like early medicines also we have. And because of this, actually we want to protect all these things. Okay, and they cannot file the patent for this traditional knowledge, and they cannot ask us to pay for that. Okay, so in order to avoid that one, in order to have the biopiracy as well as unethical bioprospecting, what they have developed is our country has developed the TKDL, Traditional Knowledge Digital Library. Okay, so it is an initiative of CSIR as well as Ministry of IS and Science and Technology, Health and Family Welfare. 2001 only they have started, because of this issues with the IPs, different IPs. They have started this digital library. It was maintained by IS, Science and Technology. There were they were collecting some materials from ancient books, and they were maintaining the library for that, because in the next slide I'm going to show you one some case study, so that you can understand what is the importance of this. And these books were regarding the particularly from the medicines, Unani, Siddha, Ayurveda, Yoga. So they have all the they have taken the medical knowledge from Sanskrit, Hindi, Arabia, Persian, Urdu, Tamil, and they have maintained these library in English, German, French, Spanish, and Japanese also. Okay, for them also easy to, for them if they are filing in India, they can understand. If they are having some traditional knowledge, they will not file it. Okay, so for that case only they have converted in they have translated these books in other languages also, so that they can have a reference for that also. So if you understand this this case study, then it will be easy to understand why traditional knowledge digital library is important. Okay, in 1995, actually United States University of Mississippi Medical Center, actually they were finding some turmeric. They have wound healing property, and they are filing the patent over there. Okay, once you are going to file the patent over there, then the farmers or traders from India, they cannot import the turmeric to that countries, because they have to pay they have to get the license from them, then only they can do it. Okay, so but in case of wound healing, actually we are using for a long traditionally we will be using for everything, we will be using this turmeric only, right? For even small wounds, from larger wounds also you will be using this turmeric, and it is part of our culture also. But if they are getting their patents, then it becomes really difficult for our traders as well as for our farmers to sell their products in US. Okay, so for that actually the our government has formed a team from CSIR, under the leadership of R.M. Maselkar. Actually, they were referring some extra books and everything, and they found that they argued before the USPTO that these are traditional knowledge and is available in our traditions, and therefore it cannot be patented. Okay, and at last actually they have revoked, the USPTO has revoked, and we got some they were mentioning that they were mentioning like you are using this turmeric for external wound healing, but we are using for internal wound healing. But our Indian team actually they have read all the books from the Persian also. They have found some Persian literature, and they found that these beings are being used during pregnancy, actually delivery. After delivery, they are for the umbilical cord. After cutting off the umbilical cord, they are making the turmeric inserted into the umbilical cord of mothers, and for internal healing also. So those literatures they are showing as an example, and they make the patent to be revoked. Okay, so patent to be revoked. One second. Um, Patent to be revoked, and actually USPTO has revoked it. Similarly, some of the 200 patent applications has been revoked by using this traditional knowledge digital library, particularly pharmaceutical companies of United States, Great Britain, Spain, Italy, China, something like that. But that's why it is necessary for us to maintain this traditional knowledge digital library, and it is necessary for each and every citizens of our country to contribute to this traditional knowledge. If you are having some traditional knowledge of medicines, or even from other things also, you can be part of this. Okay, so you can share your knowledge according in this one. And that's all about your IPR, basics of IPR, as well as some knowledge about this traditional knowledge digital library. And in case of any doubt, you can just ask me. Mm. Please let me know if in case of any doubt if you are having. Aparna ma'am.
Ma'am, thank you so much. Amuda ma'am.
Uh,
Thank you, ma'am. Thank you so much, ma'am, for the wonderful presentation.
Thank you, ma'am. Thank you, ma'am. So,
Thank
in
you.
case
Thank
of
you so
any
much.
doubt from the participants, they may ask, ma'am.
Ma'am, actually, I think you can see the comments. They have like flooded the chat box with messages stating that it was a nice presentation. It was very clear. You explained with examples and illustrations and all.
Thank you, ma'am. But apart from that,
Thank you.
any
Thank you so
doubts?
much, ma'am.
Okay, ma'am.
Participants,
Thank you.
apart from this, if you have any doubts, I think ma'am is available. You can post your questions in the chat box so that ma'am can answer. Ma'am, I think we don't have any questions, ma'am.
Okay, ma'am. Okay, ma'am.
Okay, ma'am. So let me conclude
Uh,
the program with the official vote of thanks. So, on behalf of the Internal Quality Assurance Cell, first and foremost, I would like to thank our Honorable Founder Chancellor, Thira A.C. Shanmugam Sir, and our beloved President Engineer ACS Arun Kumar Sir for their constant support and motivation. Next, I would like to express my heartfelt gratitude to our IQAC Chairperson, Dr. S. Geeta Lakshmi Ma'am, our Director IQAC, Dr. Malini Pandey Ma'am, and the Deputy Director IQAC, Dr. Subhashri Sharma Ma'am, in a guiding light in all our endeavors. At this juncture, I would like to thank our Amuda ma'am. Ma'am, thank you so much for spending your valuable time with us and enlightening our audience with what is meant by IPR. So, why is IPR needed? The examples. So, thank you so much for explaining it in a very neat with illustrative examples also. Thank you so much, ma'am. I would also like to thank the organizer of this event, Gomati ma'am, who also I would like to thank Kanya ma'am, IQAC in charge, and the entire IQAC team for making this event possible. Last but not the least, I would like to thank all the participants for participating in this event and making this a grand one. Thank you so much, ma'am.
Thank you, ma'am.
Thank you, ma'am. Dear participants, two link has been posted in the chat box. So I kindly request you all to fill both the links. So once the link is filled, automatically you will get the certificate to your registered mail ID. Ma'am, thank you so much, ma'am.
Okay, ma'am. Thank you, ma'am. I'm leaving.
Yeah, yeah, thank you, ma'am. Thank you, ma'am.